Chapter 7, we're going to talk about agency relationships. So the first slide covers the two parties that would be involved. So we'd have a principal and an agent. And my best example that I normally give when I talk about this is a real estate agent, because everybody has pretty much familiarity with a real estate agent. So the real estate agent is obviously the agent. They're an independent contractor. They're normally self-employed. They maybe work with a real estate agency, but normally they're still considered self-employed. Then you, if you're selling your house or buying a house and you go out and you contract with that real estate agent, you are the principal. So in a sense, you are hiring them. With a real estate agent, you only pay if you actually sell your house with them, but it's still that type of a relationship. And there's that fiduciary relationship that's based on trust and confidence. Again, say you're selling your house, you're going to let that real estate agent take people through it. You're not going to be there. You're going to let that real estate agent maybe have open houses. Again, you're not going to be there. So you do trust and have confidence that they're going to protect your property. So then we get into, okay, well, what's the difference between an employee who could also be an agent? Just because someone's an employee doesn't mean they're not an agent, or an independent contractor that's an agent. So this can be a hot topic in some businesses because businesses may like to push people out as independent contractors so they don't have to pay payroll taxes. Doesn't necessarily make that right, but a lot of times companies do that. So an employee is a person who works for the principal, works for the employer. They get a paycheck, they have their taxes withheld. The employer completely controls their working conditions and their method. The employer provides their tools and their equipment, and then the employer is going to be liable for the acts of that employee. So like, let's say, for instance, you own a landscape company and you have people who come and they get in the truck with you and they go out and you take the lawnmower off the truck. It's your lawnmower. They're going to use it. They're going to mow that lawn. They're going to maybe, put fertilizer out or whatever they're going to do. And you tell them, hey, you got to be here at 7 in the morning. That's when our day starts. We're done by 4. So you're controlling their working conditions. You're giving them the tools to do their job. Now, say if that guy who's in that mower runs over a lady's prize petunia, you're going to be liable. If that was your employee and you gave him that mower and told him to do that job and they ruined something, the employer is going to be liable for those acts, as long as it's within the course of their jobs. We're an independent contractor, so say maybe you're a bigger landscaping company and you hire another landscaper who also he's in the market, he's also doing his own jobs, he's marketing himself, but maybe you just need a little extra help. So then you hire him to do a job that maybe is too detailed for your staff to do, or so then he truly is an independent contractor. He still is working on his own. His working conditions is not going to be controlled. He's going to have his own tools. You're not going to tell him, hey, you got to show up at 7 and you can't leave till 4. You're just contracting his services to do a job. Now, if he then did something wrong, he would be liable. He would be liable for his own negligence or act that caused some sort of damage. But so it has to be that, and a lot of times what the IRS will do, because I've done accounting for different small businesses, and there was a time that one of the small businesses was questioned. They will ask, is that person who's considered an independent contractor, are they marketing themselves to try to find other jobs that are comparable to what they're doing for you? So like, say for me, if I'm doing accounting services, am I out there and could I go do accounting services for any business out there? If that answer is yes, I could and I try to, then you're an independent contractor. If it's like, well, no, I expect this person to come in Monday through Friday, 9 to 5, and I do not want them working for somebody else, then they're an employee. So a lot of times the IRS will look at it from that standpoint. But you do want to understand the difference between those two. Okay, so then how are agency relationships formed? So we've got by agreement, which would be the most common. So like back to my real estate agent example, you're going to have a written contract with them that says, hey, sell my house. This is the asking price. This is how much commission you're going to get. We're going to sign it and we agree on it. So that would be an agency by agreement. Now, it doesn't, I mean, in a real estate contract, it has to be in writing, but not all agency relationships would have to be in writing. It could be based on conduct or an oral agreement. An agency by ratification is when somebody who really isn't the agent but is acting on behalf of somebody else contractually obligates that person into something. So like say for instance, if you, like when I worked at the oil and gas company, our administrative assistant would sometimes call and order copy paper. So say the regular purchasing department, you know, they did their thing too. But so say if we really needed it, she might pick up the phone and do it. Well, she's not normally the person who did it. She wasn't the purchasing agent. But because they knew she worked there, they delivered the paper to us and then we paid for it. That would be an agency by ratification. We saw that she ordered paper, we approved it, and we paid for it. So we were, in a sense, authorizing her to do that. Agency by estoppel is when the principal would cause somebody else to believe that there's that person's their agent, and then they pursue some sort of a relationship. So say, you know, if you do own that landscaping company and your best buddy pulls up in the truck beside you and you guys both go out and talk to that homeowner, they're just going to assume that, hey, this guy must work with you. So then if that guy came back later and approached that homeowner and got some money or got a job, they're going to believe, hey, that he's an agent because you led us to believe that. You let him stand here and talk to us and you didn't clarify it. So that would be an example of an agency by estoppel. Agency by operation of law is sometimes in emergency situations, things have to be made. So, I mean, say, you know, you've got an employee at work and they're having a heart attack and you can't get a hold of anyone in their house, you're going to call 911 and have them come and take that person to the hospital. So then in that case, that would be an agency by the operation of law. Duties to the principal. So the agent's duties to the principal. So again, I'm going to go back to my real estate example. Whoops, sorry, too far. Performance. Obviously, if we're hiring a real estate agent, we would hope that they have diligence and skill, that they are, you know, that they are certified to be able to sell our house, that they know the market, that they know how to advertise it. You know, just everything that we would expect of a real estate agent, we are going to expect them to perform in that way. We expect them to notify us. So say they do have an open house and they have 10 people who go through it. I'd like to know, well, what did the people say? What was their feedback? Was there anything relevant? Again, they don't have to give you every, you know, minute by minute detail, but they should not let you know, say everybody comes in and says, oh God, I hate that carpet. That's horrible. You should know that they should notify you of that. We expect them to be loyal. So like say with my real estate example, if say your real estate agent is representing both the buyer and the seller, sometimes that happens. You know, they know somebody who is looking for a house in your neighborhood and they contact them. They're going to represent the buyer and the seller, but you expect them to still be loyal to you. You know, that there should be no conflict of interest, that they're not sharing information to that buyer that's going to result in a lower offer or something like that. Obedience, again, they should listen to you. So if you say, no, I only want to do one open house a month, obviously they shouldn't show up every Sunday. Or if you say, I can't have any showings before 3 o'clock because I'm at work and my dog's loose in the house, they shouldn't be showing up at 2 and opening that door and then there's your dog. So again, they should obey what you've told them. And then accounting, they should account for any money and property. So you're probably not going to give your real estate agent money, but they are responsible for your property. If you come home and your TV's gone after an open house, they're going to be responsible for that. Then what duties do we have to that agent? Obviously, we need to compensate them. So with the real estate agent example, if they do sell your house, you agreed to pay them a certain percentage of the sales price. You should reimburse them for anything. So a lot of times your real estate agents will pay for like the inspection. So maybe say there's a well or septic inspection or a termite inspection, because the agent is normally the person who meets those people at your property, they can pay, and then it'll come out of the closing normally. But so you're going to reimburse them for that. Indemnification would be that if there was any type of liabilities that were incurred as a result of their agency relationship. So, I mean, if they did something that directly related to selling your house and they ended up being liable for that, you would indemnify them, or you would pay for that liability. You should cooperate. So cooperate with that real estate agent. So, like, again, if they are going to show your house, you should have it clean. You should have the dog out. You don't want them to come in and you're laying on the couch, binge watching Netflix. You should be gone and the house should be looking good. Provide safe working conditions. So again, if your house does have any dangers, those would have to be taken care of actually probably before you put it up for sale. Whoops. Because you don't even want people coming through. Sorry, my computer popped back. Okay, so that was safe working conditions. Now, the agent's authority. So these can kind of get a little bit confusing. Express authority is what you've specifically given them. It's either in writing or it's written. Implied authority is inferred based on their position. So if you're a store manager, the implication would be that you probably could fire employees if they're not doing their job, or hire new employees if people are coming in and filling out their applications. Apparent authority is that based on the principal's words or actions, it causes that third party to believe that they have the right to behave that way. So a lot of times it's conduct over time. So, like, let's go back to that administrative professional that would order the copy paper. We gave the supply place, we gave her apparent authority to say, because she's done it in the past and we've paid for it, they're going to assume that she's got the right to do that she has that apparent authority. Again, the ratification is kind of what I just said about that, like that office, the administrative office professional. She acted on our behalf. She was obviously a grown adult. She had legal capacity. She knew the material facts, or we knew the material facts that she purchased that copy paper for us. We affirmed the entire deal. We paid for it, and it's a done deal. So you could kind of put that into any scenario. So I mean, say you have an agent who's going and trying to sell windows for your window company. You know that they've got their adults. You know that what they've quoted. You say yes, that sounds great, and you've just ratified them as your agent. To rescind it would be like, so say if that administrative office professional just thought, hey, I'm going to order the paper, and we didn't really want her to do that, and she ordered way too much. As soon as it would come, we could rescind it. We could have contacted that supply company and said, hey, listen, we didn't give her the authority to do that. We're going to return all of these, and we're not liable. And then we would not be. So from a liability standpoint, the principal is who's going to be liable in the contract, and they're the ones that would have to have the legal capacity and meet all those legal requirements of a contract. So the agent actually could be a minor because it's going to bind the principal. As long as the principal's an adult, then they would be liable for the contract. And then, so the principals could either be disclosed, where the identity of that principal is known to the third party. So, like, say with my window sales example, they come and say, "Hey, I'm with this window company, and it's on the notepad, it's on the card, it's on everything they're giving you." That's a disclosed principal. Partially disclosed is like a real estate agent. So when they're showing the house and they're doing an open house, people know that it's not their house. They know that they're a real estate agent. They know that there's another party involved. They just don't know who that other party is. It's not disclosed by the real estate agent. Undisclosed means you don't even realize you're dealing with an agent. So sometimes, like when people win the lottery, they'll send somebody to claim those tickets, and we don't even know who the party is. that actually want it. Or like maybe movie stars could do that too. Like if they're making an offer on a house, they don't want the people to know who they are. Then the principal's liability is they're going to be liable for anything that that agent does within the scope of the employment. Obviously, if there was any criminal activity, they're not going to be liable for that. But anything that they're just going about their regular business, they would be liable for those. They also would be liable for any misrepresentations that the third party relied on. So if this person told them something on behalf of that principal is going to be liable for that misrepresentation. If it's an independent contractor, again, like we said, if it's a true independent contractor and the employer did not control their job or their tools, they are not going to be liable for any wrongs that that independent contractor committed. They are going to be liable. How do we terminate agency relationships? So either the most common way is to just say the contract has been fulfilled. So with my real estate agent example, the house is sold. So that agency relationship is terminated through the sale of the home. Another example with a real estate agent, normally you only sign for like 6 months. So maybe 6 months goes by and they didn't sell the house. Again, that agency relationship would be terminated. Maybe you just have a certain thing, like sometimes you can have people as a power of attorney while you're out of town. They could maybe sign for things on your house, or, like again, if something goes wrong and you need to have a furnace guy come out, that person could act for just for that period of time while that person's out of town. But then when that person comes back to town, that person is no longer their agent and they would not be liable for things that they committed to. It could be mutual agreement. Maybe you just decide, hey, this isn't working, like with your real estate agent, I don't want to sell my house anymore. Or again, canceling by one of the parties. If there was any third parties involved, so especially say you're a sales agent for a company, when that sales agent would quit, anyone that they dealt with should be notified so that everybody knows, hey, this person is no longer our agent. So then that just protects the principal from anything that could happen later on. Or it could be operation of law. So like if the person dies, if they are no longer mentally capable of making decisions, if it becomes impossible because of like say with the real estate example, say my house burns down, you can't sell it if it no longer exists. If I went into bankruptcy court, or maybe I'm getting a divorce, there's a war, there's something crazy that happens, and we need to terminate that contract. Okay, so that is chapter 17.